crime in the Wisconsin versus Mitchell statute, we now know that words can be the source of a crime. In fact, the US Supreme Court said the words that are used when you're committing the crime can be the basis of the charge that you're talking about. We're going to talk about that too. But also, let's say you might be a member of an organization. If that has some connection to what you're doing, that membership can also be used to show your motivation. So we didn't stop with the fact that you had this malicious intention, this hatred, if you will. The courts couldn't stop there because it would be punishing how you think. They said instead here in Pennsylvania, as they did in Wisconsin, you have to commit first another offense. Now, if you look here, the next phrase says he commits an offense under any other provision of this article. Now, the legislature dropped the ball in that little phrase because I've asked many people what the words this article might mean. You might ask yourself that question because not many people know the answer to that question. But the answer is found in the structure of the Crimes Code here in Pennsylvania. The Crimes Code is found in Title 18, which is broken down into articles A, B, C, D. And in fact, the articles are then are broken down into chapters, and then those chapters into sections. The police officers that are on the street are more familiar with sections, not articles. So if you see there an entire article, we're going to talk about when we flip the page here what that is. But then they went to Article C, and they took out a chapter exclusive of one other provision, and those are the property destruction type of things that might be charged as an underlying offense. Under Article B, they're the crimes against the person, many of them. And the one that's excluded was in 1982, the legislature not only created ethnic intimidation, but they also created the crime of institutional vandalism. The legislature said that institutional vandalism cannot be an offense to which you add this charge of ethnic intimidation. Then they added one section under Chapter 35, criminal trespass. And if you do it toward one other person or a whole group of people. Tamika, if you, next slide, if you will.
Okay.
Thank you very much. If you have questions, I don't know how you're going to do that, but email me, I'll try to answer your questions. Can you go? There we go.
Which one?
Yeah, okay.
This good?
Yeah, just back up just at one quick one down at the bottom there. This is an important feature of this crime of ethnic intimidation. The grading is dependent upon to which crime it's added to. For instance, an assault in Pennsylvania is normally a second-degree misdemeanor. If you say the assault was done because of a hatred towards someone's race, color, religion, or national origin, that crime of ethnic intimidation is the next degree higher. In other words, it skips up to the first-degree misdemeanor. So you're charged with two offenses. First-degree misdemeanor, ethnic intimidation, second-degree misdemeanor, assault. So what it does is enhances the exposure to punishment to perpetrators that choose to perpetrate their crime out of hatred towards someone's race, color, religion, or national origin. Tamika, if you pass on there. Now you're going to see here, here's some of Chapter 25, the homicide offenses. We don't see that very often. They're already pretty significant. Onboard children offenses, keep going. Now the next one, if you go ahead, Tamika, yeah. See the assault offenses? Look at simple, aggravated, terroristic threats, harassment. Why do people do that to each other? Oftentimes there's an underlying dislike, ill will, hatred, malicious intention. And if there is, not only can that underlying charge be charged, but then you add to it this punishment enhancement charge of ethnic intimidation. So simple assault, aggravated assault, terroristic threats, harassment are some of the ones we see frequently as the underlying offense. Now, it could be any of those offenses listed there, but the ones we see most frequently are the ones that are highlighted for you. Next slide, Tamika. I appreciate Tamika doing this because I don't know how. Kidnapping offenses, we don't see those very much. Sexual offenses, abortion, I've never really seen one of those. It's, can be sexual offenses you might see. But look under arson. People burn people's stuff down because they don't like them sometimes. They burn their house down. Or the big one is criminal mischief, the vandalism provision of the Crimes Code. Now, we do know that it depends on the value of the offense, criminal mischief, how that's graded. $500 and less is just a summary offense. But guess what? If you commit that summary offense with a malicious intention toward race, color, religion, or national origin, now you're charged also with a third-degree misdemeanor charge. Okay, Tamika. Burglary, that's the other one there. Now look at this. Oh, back up one more. Back up there. Oops, what happened? The one with the vehicle. Tamika. Yeah.
You want the one with the vehicle? Okay.
There you go. Yeah, see that picture of the car? Think about it a minute. What can be charged here? Now, it's clearly a criminal mischief unless the person that owns the car did it, but that's unlikely. If they didn't do it, someone else did it, and it's clearly criminal mischief. Now the question becomes, what was the motivation? And you look at the words used, it might be that the person doesn't like people who are from Islam or Muslims. If that's the case, you can also charge not just the criminal mischief, but ethnic intimidation as well. You know, listen, I'm going to tell you something right here. The person on whose car that's scrawled is clear to them in their mind why that happened. Sometimes the objective officer that arrives looks down the street and every car in the street has some heinous thing scrawled on it. And maybe it wasn't because they're Muslim. It might be just a kid joking around, but the party to whom that's done is in their ear, it's screaming to them, this is done because we're Muslim. Okay, Tamika, you want to?
And Carl, and may I add there, if you look at that image, there is a piece that's blurbed out there. So the Arab Muslim, while that's certainly an insult, that's not an expletive, you know. So, okay, fine, you call someone an Arab Muslim and they're meaning this in the most offensive way. But in addition to that, there is also blurred out there an expletive. So there's probably another word, and I can't imagine what it could be. I don't know, N-word or something similar for a person who is an Arab Muslim, you know, to put with that. However, they're putting that insult together. It's something bad that it's even blurred out there in that image. So, you know, what we know is that the person who put this, they absolutely meant this to be an insult. And if you also look at the tires are slashed. So it's been banned.
Yeah. Now, we're going to get to this in a little bit about harassment. You harass somebody, criminal mischief is clear, but when you harass somebody, you're doing something against them which has intent to harass, annoy, or alarm. Be the person who gets up in the morning and sees that on your car. Do you feel alarmed about that, or harassed, or annoyed? And so that could be harassment as well. If you would go to the next slide, I think I can't even see them because this thing here is covering mine. No, I don't know what I'm doing. Okay. Is the next slide ready? Why can't I see it, Tamika? Did we lose it? Tamika, are you there?
Sorry, I lost connection for a second. It went out for some reason.
Okay, I wondered what
I'm
happened.
sorry. I didn't.
Because I have no clue what happened. Thank you all for attending today, by the way. I appreciate you coming and listening.
So I started adding a comment. Did you all hear? Were you all able to hear what I said? I'm not sure at what point I went out.
That was on there when you talked about there's another blurb on there that's really.
Oh, I was saying yes, that there was something that was an expletive that was also typed on there. And if you looked at that image really closely, the tires were slashed, the windows were done, they crashed into the front of the car, so the hood was up. They had completely vandalized the car and like probably beat it with a bat. And so there was also some type of curse word in addition to the insult, with them using the term, their identity against them as an insult, Arab Muslim, and then they called them something else. So the family who was victimized by this, the people that this was done to, it's pretty clear that this was done because of their ethnicity, Arab, their religion, Islam, or, you know, because they are practicing Muslims.
Okay.
Let's see if I can start sharing the. Oh, okay. Randy says it says F off, Arab Muslims. Thank you.
Thank you, Randy. I don't see the next. There we go. All right. Well, look at this. This the grading, we talked about this. It's the next degree higher, whatever that value is. And as Tamika was talking, you slice someone's tires and smash the front of it, you're into a high level criminal mischief where you add the next level up. Okay, go to the next one, please, Tamika. Thank you.
Mhm.
Try to bring this over here. Okay, look at this here. Now it's clear we talked to a lot of victims about a lot of discrimination and things that happened to them. But with hate crime, they feel anxiety clearly, helplessness, isolation, withdrawal, sleep disorders people have. There's a confidence lost in the system. In fact, this program really began with why this was even done. Back in 1982, people didn't have a lot of confidence in the system, those that are victimized by hate. They also said there's a frequency of this was on the rise. These things were more and more. So the legislature stepped out and tried to do something. The harm, by the way, is very distinct. You know, I told you the Wisconsin versus Mitchell case talked about this harm. Picture a moment, if you will. I often use this example. Friday night, a synagogue lets out and the rabbi's walking down a tree-lined street, maybe looking at the colors that are changing now. And who pulls up beside the rabbi but a car with 3 skinheads, and they jump out and beat the crap out of that poor rabbi. Now, who's your victim? Now, clearly the rabbi's a victim there. But what about the members of his synagogue? Do you think they feel any of those feelings that were listed there? If you go to the next slide, Tamika. I don't know what's happening there, but there we go. You think they feel vulnerable, isolated, maybe? Infiel, inmoral, deshonesta, desleal. Anyway, so the people in the synagogue are fairly clearly, how about every Jew in that city? How about every Jew in that region of the Commonwealth or throughout the Commonwealth? This east coast of the United States and somewhat across the country. So the victimization of these things is widespread. But be clear, the courts understand that, and the Supreme Court did in that case that they had. But one of the things I don't like to see on the reasons for this having happened, people lost confidence in the government, in the police. That's bad. Police community relations are bad for a variety of reasons. We don't like this to be one of them. Okay, next slide, please. Now, I said to you, the list of those who might be victimized, to which you could then seek out to add this ethnic intimidation to a charge that's being made against the perpetrator of some crime to them. Now, I say some crime, only those that are listed by the legislature, but one of those crimes, race, color, religion, or national origin. Do you think there's other groups that might want to be included in that? The answer should be yes. There, look at there, that lady, she is elderly. She may feel people hurt me and look to do things against me because of my age. If the next slide, Tamika, you'll see, here's the LGBT community. How about the next one? Mental and physical disability. These folks want to be included as well. Now, if you go to the next slide, you can think of other categories that the legislator could have put in there, but had not back in 1982. But guess what? On the next slide, you're going to see something that I'm going to pose a question to you after we review this. Because in 2002, the legislature amended this provision of the Crimes Code to do what? They included some other protected groups that if the crime is committed against them, you could also add ethnic intimidation. And who did they say? They said those ancestry, sex, gender or gender identity, and sexual orientation are categories they added. Intellectual disability, physical or sensory disability. Those that have those issues. That's in 2002, okay? But guess what the legislature did in 2002? They added that amendment on a farm bill amendment. So they tried to combine the two of them together to make this amendment to the ethnic intimidation provision. In doing so, many of us are unaware of this, but that's an unconstitutional way to amend the Crimes Code. So, of course, an action was taken. Now, I got to tell you, when LGBT issues come up, people come out of the woodwork to prevent any protections to afford to the LGBT community, not just in this area, but other areas we see this as well. But here, someone challenged this, and they said that the legislature didn't do that correctly. And the court, the Commonwealth Court, said, you're right about that. So they struck down that amendment. That when they struck down that amendment, my thought was, well, what do you think I was thinking? I'm gonna tell you what I was thinking. Well, go back and do it right. But they didn't do that. They appealed it, and the Supreme Court of Pennsylvania agreed with the Commonwealth Court, saying it was done unconstitutionally by adding this amendment to the Farm Bill. Therefore, that's struck down. And that happened in 2007. Now, from 2007 till today is 13 years. Has this been amended again to be consistent with what they attempted to do in 2002? The answer is no. Now ask yourself, are there members of our legislature that really don't want to see this in there? The answer is yes. Because look at, from 2002 till now, it still isn't in there. It's proposed, but it doesn't happen. I'm pretty cynical, thinking that, did they ever really intend to do it back in 2002? How many legislators don't know that you can't attach something to a different bill of a different nature, because to do so under our Constitution is unconstitutional? But anyway, it still remains that that's not in there. I always ask people, talk to your legislators. If you're interested in seeing it in there, talk to them, ask them to put it back in there, as they did in 2002. There was an attempt in 2019 in Senate Bill 947, if you ever want to look that up, to make these corrections. I say corrections, these additions to the hate crime legislation. Okay, these are the gradings. In Pennsylvania, every crime carries with it a grading. So think about this a minute. So what? You commit a crime because of your hatred towards someone's race, color, religion, or national origin. Well, in theory, if you look at this list here, we'll go back to that simple assault, second-degree misdemeanor, 2 years and $5,000 fine exposure. That's not what happens. That's theory. Now, in theory, if you add ethnic intimidation as a reason for that assault, what happens? It just about doubles. In fact, it more than doubles with regard to exposure to prison time, from 2 to 5 and from 5,000 to 10,000. That's in theory. In practice, those learned judges and others that see what's going on here know that this is infesting our communities. Remember the Supreme Court in Wisconsin saying this has a retaliatory aspect to it, and it's hurting our communities. So therefore, they're allowing legislatures to pass these types of laws. So that's, judges are putting people in jail. Now, how many cases get there? A lot of them don't, because guess what? You take a simple assault, you're in front of the magistrate. Magistrate's liable to say, let's reduce this to disorderly conduct, and smack the guy's hand and say, don't let me see you in my office here again. That's kind of like the reality out there. But with this, the person that's a perpetrator, oftentimes when it's exposed that they committed that offense with a malicious intention towards somebody, they're not proud of that. That's the person you see trying to get away from the cameras and be not seen, because they're people they work with, the people they go to school with, or the people they go to church with, their neighbors. They don't want them to see that, so they look to the judge and say, would you accept my plea to the underlying offense of assault? That's a good plea bargaining tool that I believe is being used throughout the Commonwealth. Okay, can an offense be done with words alone? Now, as far back as Wisconsin versus Mitchell, the court has said yes. Even further back, the answer to that question is yes, it can. Current cases here in Pennsylvania say the same thing. Words alone can be a crime depending upon what's said and how it's said and where it's said and things like that. If you look here, here's 2 examples of when harassment can be committed with words alone. The first example comes out of a long-term case up in Connecticut. And that case said If you issue words to somebody that are likely to incite an immediate breach of the peace or injure somebody, they're words that are called fighting words that have lowered protection of the First Amendment of the Constitution. So you just can't be out there in the world saying whatever you want to whomever you want, anytime you want. The other one you'll see there, you'll see captive audiences. We here at the commission have cases where, for instance, neighbors stand outside of someone's house yelling slurs at the family. Well, guess what? That family is a captive audience. Things you might be able to do on a street with a sign as you're walking by in a parade or something, you can't do that in front of someone's house because they're a captive audience. So there's two examples. I keep looking at the time there, because an hour really isn't a lot of time to cover all this stuff. But captive audience is an important ingredient. But the more important one is fighting words, those which are likely to incite an immediate breach or result in injury to somebody. And the courts don't really deal with the injury component. I don't know why, but for over the years, I've not seen that. But one time here in Pennsylvania, there was a police officer. They said the words that were used to that police officer injured that police officer. Wow. That's the only time I've ever seen that. But they go on this whole idea that what you're saying invites an immediate breach of the peace. Okay, Tamika, let's see what we got.
Tammy.
This is the law, First Amendment, part of it
Hi,
anyway.
Tammy.
Someone
Hi, Billy.
someone needs to be muted, Tamika. I don't know who it is. But if you go back there, the First Amendment basically says a lot of things, but one of the ones about free speech is Congress shall make no law that abridges the freedom of speech. A lot of people think that gives them freedom to say whatever they want and wherever they want and to whomever they want. But if you look at the next page there, look at those. Lewd words, obscene words, those that are profane or libelous, and fighting words are not that protected by the First Amendment. So you can't just say what you want, wherever you want, to whomever you want. And let me say something about this. I've long understood and believe that things escalate. What do I mean by that? Let me give you an example. Down in Shenandoah, there was a fellow who was from Mexico, would walk through a park, and in the park were some youth that would yell slurs at this gentleman as he'd walk through the park periodically. Well, the slurs escalated to the point where they beat him up so bad that he died. Now, had someone told those young men, that's wrong of you and it's unlawful of you to issue slurs to this fellow because what you're doing are fighting words unprotected by the First Amendment, and that's harassment. That harassment can be charged. If you'd like to have that done, continue what you're doing, but otherwise stop that because that's inappropriate and that could be harassment. And because of he's Mexican and you're yelling slurs at him, it can be ethnic intimidation. They didn't do that. Instead, that was let go until the point where those young men killed the gentleman. We've lost the gentleman. The young men went to jail. So had they stopped that earlier, that all could be avoided. In our communities, I believe this stuff happens. People say things on the street to each other. They come up to each other and say some slur to them. Now let's look at harassment a minute. You don't have it there and it's not on the stuff here, but I'm just going to read you a couple of paragraphs out of here. The harassment provision of the Crimes Code, section 2709. You commit harassment with intent to harass, annoy, or alarm somebody. Number one, you engage in a course of conduct or repeatedly commit acts which serve no legitimate purpose. Now, the court has struggled with those two features, a course of conduct and repeatedly commit acts. Is saying something to someone an act? The answer is can be yes. There's a case here in Pennsylvania where a young woman was in her lounge at college doing some things. It was late at night and this fella came in, was kind of mumbling and fumbling around. She knew he wasn't supposed to be there, but didn't say anything. Well, she fell asleep and she woke up later with this fella in her face asking her for illicit sex act. Well, she said, get away from me. He asked again, get away from me. He asked the third time. Get away from me. He left. He was arrested, charged with harassment. The question is, he did it 3 times. He said 3 times asking for sex. Is that repeatedly committing acts? The court said, yes, it is. He said it more than once. Do you see it on the street where people say things to each other? They don't stop at one time. If they did, they get that one bite of the apple, but they don't usually stop there. They say it more than one time. So you have the potential to see a harassment situation where someone is stopping someone on the street or confronting them or stopping them from walking or going up to them, saying things to them that they shouldn't be saying about some ethnicity or some quality that they have that's race, color, religion, or national origin, meaning that that could be a harassment. And then you add ethnic intimidation as the motive for that confrontation on the street. That's important because there are people that think you can say what you want. It's clear if someone hits somebody, the First Amendment doesn't necessarily come to play. But when you're saying things, our courts have said any number of times that words alone can constitute a crime. And the cases are out there, and those are related to words that are fighting words. Very important feature to this ethnic intimidation. Because again, those low-level incidents sometimes are kind of pushed to the side. What happens is the community feels totally irate, nothing's being done about this, and or vulnerable. They feel that they're victimized, which is really a bad thing because, again, who is the victim when this happens? Not just that person to whom those things are said or done, but the colleagues and others that share the characteristic that they can't change about themselves. That immutable characteristic that caused this to befall them, to be the victim of a crime, which is totally inappropriate. And I believe our society would do well to take a look at fighting words more carefully, because they're words that the courts have been clear. Words alone can constitute the basis of a crime. Okay, let's see the next one. Now here's an interesting one. In 1982, the legislature said to those that are victimized by hate crime, guess what? We're giving you a specifically designed civil remedy for your victimization. And they told everyone about it. They didn't put out banners and on first page of newspapers and things. They put it in the footnote to section 2710. Now, most lawyers don't read the footnotes to the crime code provisions. Certainly, those that are victimized don't read that. But later on, they actually codified it and they put it in 42 Pennsylvania Consolidated Statutes, section 8309. Still, it's kind of hidden. People are unaware that they have a civil cause of action for these things. Let's see here. Okay, what's the next slide say? I guess the bottom. Yeah, here we go. Now look at what can a victim attempt to accomplish by suing somebody that's victimized them because of their race, color, religion, or national origin, and it was done with one of those underlying offenses the legislature said can be the underlying offense to which ethnic intimidation can attach. Look at number 1 there. General and special damages, including damages for emotional distress. Any lawyers watching? I saw your eyes roll back because whenever you see that, kind of a lawyer says, oh, that looks like a prime candidate for me to take that case. Now listen, someone in the legislature wrote the next phrase. Damages under this paragraph shall be actual damages or $500, whichever is greater. If you go see a lawyer and you have emotional damages from being victimized by a hate crime, and he says or she says to you, we can recover $500, what do you think you should do? When I was a young Marine, I knew how to do an about face. And I think that's appropriate in that circumstance. Turn around and walk out of there. It's not worth $500, the emotional stress that people are put through because they're victimization by hate crimes. How about the general damages? Well, we have to know what happened. Let's take a for instance, okay? There's a Chinese restaurant and the owner is closing up and it's 1 o'clock in the morning. Near the restaurant is an unmarked police car watching sort of what's happening in the community. And a carload with 2 young men stop. And the first thing they yell is some slur about the Chinese and that they're bringing the COVID to America, and just irate and start beating on this poor guy. Now, the police pull in there and arrest the 2 guys right away. And they say, "Are you okay?" He says, "Well, I'm not sure. I know they broke my glasses and I think my rib might be, I don't know. I hope I didn't break my rib. And my tooth, is my tooth broken? It is? Yeah." So that person has general damages. The glasses, the rib, the medical attention for that, and the tooth. What is that, $4,000? You're gonna find a lawyer to go for $4,000? Not so much, not so easy. But look at number 2. Punitive damages, damages designed to make the person that did this hurt financially. Hurt financially. This person that did it was going to buy a boat, but guess what? The person to whom they committed this offense is now going to buy the boat because damages are awarded to punish the person financially. How about number 3? You're going to find the lawyer for $4,000 case? Well, they're going to get their attorney fees. And look, it says reasonable attorney fees. That's redundant, I think. Well, I hope you're laughing about that, but reasonable attorney fees. Lawyers will take these cases. Imagine, Your Honor, my client suffered general damages in the amount of $4,000. He had dental, eye, and medical care for proposed rib injury. $4,000 general damages. Yes, Your Honor, I've been very diligent in this case. I've gone to a number of pre-trials and I've gone to the scene and I've talked to this family about their concerns. We're going to go back to, Your Honor, we'll go back to the emotional damages and punitives, but for now, you're asking me my fee, $62,500. Can you see the perpetrator, their eyes go, what? What? You're going to get those fees. You're going to find a lawyer for this case? You bet. You bet. Let me take you out of Pennsylvania a moment. And I see this here in Pennsylvania. I've seen it recently. Cross burnings. There was a family in Texas, young family, 2 small children, moved in a predominantly white area and they're black. What happened? 5 young men, 18 to 21 years old, were apprehended right after they stuck a cross in the front yard of that family and lit it. They were caught. They were apprehended. They went to a criminal court, went to jail for that. Okay, now the civil action like this is talking about. Be on a jury a moment and know that this family is asking you to award them mental anguish damages and punitive damages. What do you think a jury or a judge in Texas would have awarded that family for a cross burning? Well, the family really never knew about it till the next morning when the neighbor said, "Hey, see that cinder there that in your front yard? Last night, some kids, I saw them apprehended. They burned a cross there in your yard." They didn't know about it till the next day. Think about it a minute. Be on a jury. What would you give that family? You know what the family got in Texas? $24 million. $24 million. Families of those 5 young men must have known their kids were a problem because they had riders in their insurance policy saying, if my kid does something, then the insurance company will pay for it. So guess what? That family's recovering those monies from those 5 insurance companies. $24 million for the general damages of emotional distress and the punitive damages collectively. You're going to find a lawyer for these cases here in Pennsylvania? Not until they know this exists. This exists. I don't know what happened. We went ahead one there.
So Carl, while we're still on this subject, I just wanted to have you answer a couple of questions that are coming through. Okay. So from Randy Duque, he has a question. He asks, but are slurs by themselves criminal offenses, such as using profane or offensive language in a protest chant?
Now, this becomes real line drawing stuff. When you're walking down the street and you have a sign that has some nasty thing on it, the person can turn away and walk to the next street, okay? But when you're in their face-to-face stuff, you can't do that. Let's say someone leaves the parade and goes over to someone along the street and yells the same thing in their face. That suddenly becomes fighting words, actionable. But while they're on the street, it's not. There's a dichotomy there of what is actionable and what isn't. When you're in the face of somebody, face to face, saying these things that annoys, alarms, or injure somebody, annoy, alarm, or harasses, ask yourself, is what's being said there a real part of a dialogue in our society? Is that really what you want to think that is? I'd tell you that the answer to that is really no. Let's see here. The courts look at, is this something that, here we go. Words alone can be actionable. Here's what they said in this one case. Approprious epithets constitute such an affront to the addressee's honor and self-respect that a violent retaliatory response is assured. That was in a case some time ago here in Pennsylvania. So those, when you're in someone's face and attacking their personhood and self-respect, that's actionable. But in the street, the answer is no. And why do you think the police sometimes stand there with their arms folded and they're in their face hearing all this stuff? Because guess what? When you say it to a police officer, and I got to tell you, when I talk to police, this is a pretty big pill to swallow. When they're in the police officer's face saying that stuff, it's not a fighting word. Why? Because they're trained and it's not likely to incite an immediate breach of the peace. Now, it wasn't always that way in Pennsylvania, but the courts in Pennsylvania sort of shifted and said that that's not a fighting word. But when the police officer says it to someone who's a citizen, the same stuff, it is a fighting word. And that's actionable. Police don't want to swallow it. I don't know how they stand there and listen to that stuff on the street when it's coming at them. It's really, they got to have some real serious training to absorb that stuff. Before we go on, Tika, would you please, if you can, bring up the case of Commonwealth versus Senate? It's not in this, it's one of those ones I sent you, if you can do that. Is there another question someone had you wanted to cover?
Yes, there is another question. So Corbett Anderson, while I'm pulling this up, Corbett Anderson asks, civil action is available even if the underlying crime was not charged, correct?
Yeah, that's correct.
That's his question.
That's correct.
Okay.
It's a little harder. It's easier because guess what? In criminal court, what's the burden of proof? Beyond a reasonable doubt. Person's found guilty in criminal court, you kind of trot over to civil court where the burden of proof is much less. A preponderance of the evidence, you've already proven it, you haven't, but the state has, that this was done beyond a reasonable doubt. Now you're over here saying preponderance of the evidence, a less standard, I can proceed. And if you're talking with a victim and you happen to be talking with a victim who's in court on a civil case and says to you, hey, I should drop this case because the guy was found not guilty on criminal court. Is the answer, yeah, you should drop it? Well, if some cases that are in our history teach us nothing, they teach us there's a difference in criminal and civil court. That's easier to prove your case in civil court. And why is that, by the way? Our nation is founded on freedom. In the criminal case, you might lose your freedom. You could lose that. Very important feature. And before you do, they want to be sure you did this. But the civil case isn't about freedom. It's about money. Does it look like you did it? How much should we give them? Big difference in criminal and civil. Thank you, Corbett, for that question. Okay.
So I have posted that.
Well, that's the other one. Well, let's talk about this one first. Here's a case that, I don't know if we can scroll down on this, but I'm going to talk about it. 16-year-old boy was charged with harassment and ethnic intimidation. Why? He was on a school bus going to school. On the school bus were two twins sitting right behind the driver. This happened down in Reading, by the way, right behind the driver. They were behind the driver because the parents of those two children said, hey, remember last year you had this confrontation with this older kid? It led to a fight and you were punished for it. Don't let that happen this year. Sit behind the driver. Well, they're going to school, and on the bus comes this 16-year-old who's talking about the family of this twins. They're only here, the family only here because of 15th and 30th where they collect welfare, you know, and saying things about, nasty things about Puerto Ricans. And this was the national origin of these children. And on the way home that same night, they were saying things again and shooting tampons at the kids. Well, the parents had gone to the school saying, hey, protect our children. Well, the school right away stopped everything and did that, right? No, they didn't do anything. The bus company didn't do anything. The parent of the kid that was doing this stuff to their kids, they said, not my child. That's always what you get a lot of times. Not my child wouldn't do that. Well, it so happened that the father of these twins, to whom this was visited upon, was a police officer down in Reading and knew about ethnic intimidation, charged with that young man that was doing this to his children with harassment and ethnic intimidation. That kid was convicted, found delinquent of harassment and ethnic intimidation. That's this In Re MJM, a minor. There's a citation for it there. I guess you don't need to see the rest of it. I've sort of told you about it. But if you could go to that other one, Tamika, the Commonwealth versus Senate. For any of you that work here at the commission, this is applicable to what we do as well, but this is in the criminal context. For the longest time, when this first came out, I would ask police officers and others, the motivation for this being racial hatred, race, color, religion, national origin, malicious intention, how much of the motive should be that? And they would all say, well, it has to be the only motive. You can't charge it unless it's the sole motive. Well, for the longest time, we tried to get the legislature to say that's not so. That never happened. But instead, the Pennsylvania Supreme Court stepped in this Commonwealth versus Senate case, 2011. And they did something very important in this area. And the question came up, there was a Hispanic woman and her mother were visiting, and next door was a gentleman who worked for the father of this visiting woman. He was outside throwing his tools and stuff on the cement, really making a racket. And they went outside and said, what's the matter? What's the matter? He began by telling them how hateful he was to the father because of business concerns he had. He thought he was going to take his business and sue him because he felt cheated in the business. And that deteriorated to the point where he started calling them names, like go back to the Alamo and, you know, why don't you cross the Rio Grande and you wetbacks, and calling them names. And they said, we're Puerto Rican, we're not Mexican. He didn't care, he went on. Well, he eventually was out there and he had a drill and he was kind of threatening with it. He went back inside. They had called the police. Police came and he wasn't out there, and they sort of listened and then drove away. Well, he came back out again. He had a hammer in one hand and a drill in the other and approached the woman who tried to fend him off. She lost 4 fingernails and he was apprehended. When he was apprehended, he said, no, I don't hate anybody. My motive was because the father cheated me in business. Now, the question I have for you is, ask yourself, was there also a motive of malicious intention toward the national origin of somebody? And the court said, yes, there is in this case. And it doesn't have to be the sole motive. It just has to be a motive. And the court here said, here it is a motive. And listen what the words they used. It need only be a motivation for the criminal behavior. It need not be the sole motive. To hold otherwise would, listen now, would be absurd and unreasonable. So from 1982 to 2011, there was a question, how much of the motive must be the hatred? Now they're saying it just has to be one of the motives. So that happened in 2011. The citation's there for anyone that wants to look at it. Any other questions, Tamika, that anyone has?
Yes, so We had a question from Miss Donna King. She asked, how did she phrase this? She said, is using the N-word in the schools a racial slur? And then she asked, is school discipline mandated as an ethnic intimidation offense? So I did respond in the chat that yes, the N-word is a racial slur, even in schools, though school discipline is not mandated, you know, as the question is asked, as an ethnic intimidation offense per se. But can you talk about the schools and how they are dealing with these types of things?
I'll shift my hat now. For a criminal offense, our commission deals with schools that fail to provide a school environment that's free from this stuff. The school has an obligation to keep students free from this stuff and put an educational environment for them. When this stuff is happening in the schools, there's a potential cause of action for the failure to provide that. So that kind of interaction between students, student on student harassment, the school has an obligation to stop that stuff. So frequently they don't. But in addition, the child to whom that's issued, and it happens enough, they could charge the other child with an offense. So it could be both. It could be both a civil cause of action through us. It could be a cause of action, a criminal cause of action, harassment. On top of that, ethnic intimidation, because it seems to me, and many of you may agree, that this is done because of the race of the individual to whom those words and those appropriate comments are being made. Okay, so any other questions before we turn to the next component? We have about 5 minutes left, maybe 6 minutes. The legislature back in 1982 didn't just pass ethnic intimidation. They also passed this crime. I don't know if you can bring that up, Tamika. Institutional vandalism. That's a crime that basically the legislature said, we're sick and tired of people damaging things in our communities. And the things they talked about here, churches, synagogues, places where people worship, have religious purposes in those places. Cemeteries, mortuaries, place where the dead are buried or memorialized. You know, we see this oftentimes in the paper, tombstones turned over, stuff like that. Listen to this one: schools, educational facilities, community centers, municipal buildings, juvenile detention centers, courthouses, local government buildings. And then the next one says the grounds adjacent to any of those places. I don't know quite, I've never seen one. If you dig a hole in the yard of a school or something, maybe you could get that. But listen to the last one: any personal property located in one of those places. So imagine I'm here in a government building and my coat is out on a rack out near the front door. And I go out to get it, and what happens? Someone painted a swastika on my coat. Let's say I happen to be Jewish. Okay? Now what's that smack of? Someone doesn't like Jews, right? But this institutional vandalism is not an offense to which you can add ethnic intimidation. What can you say about it? It's clearly criminal mischief. They ruined my coat. And why? Because of the religious component. That could be the charge. I'm sorry, I take that back. On institutional vandalism, because they damaged my coat, it's a personal property located in one of those places. And guess what? If the observer that sees that likely to be mad about it, if they see it and it's likely to cause someone to feel bad that happened, here, person, I can't find it here. Anyway, it can be a felony. It can be a felony if what you do causes the person that's likely to observe or discover that to be angry about it. Let me just get the real language here for you. Here. Okay. Defacing, damaging, polluting, or otherwise physically mistreating in a way that the actor knows will outrage the sensibilities, that's the words I was looking for, of the person likely to observe or discover. Do you think putting that swastika on a place where there's someone who's Jewish is going to outrage the sensibilities of that person that discovers or sees that? If so, it's automatically a felony. If it doesn't outrage, then you're automatically, even though it might be $200 to replace that jacket, summary offense, that summary offense has jumped to a second-degree misdemeanor under institutional vandalism. Could that also be ethnic intimidation? The answer is yes, it could. To what do you attach it? You attach it to the criminal mischief provision in the Crimes Code. That can be an underlying offense to ethnic intimidation. But that criminal mischief is a summary offense. So what is ethnic intimidation? The next degree higher, a third-degree misdemeanor. With this outrageous sensibilities issue, it might be a felony under institutional vandalism. So you really have three charges: institutional vandalism, felony, criminal mischief, summary offense, ethnic intimidation, third-degree misdemeanor. It's easier to show institutional vandalism, by the way, because you don't have to prove this malicious intent. But who's going to be happy that you have this idea that maybe it was done because of religious hatred? Those Jews that don't like the fact that they've been victimized, and they're appreciating that you recognize it and are trying to do something about that. Okay. Why that happened, I can't tell you. The legislature did that, but I can give you my guess is that the ethnic intimidation provision enhances the exposure to punishment for committing underlying offenses. Institutional vandalism exposes the perpetrator to enhanced punishment for the offense of institutional vandalism, for criminal mischief. It jumps it from whatever it was to automatically a second-degree misdemeanor or a felony. So there you have it. Any other questions anyone has? I've gone through some things. I usually take longer to do these programs, but we compressed it a bit, and I certainly appreciate your attention. You all were, didn't have lunch before this. I see that when I do that, sometimes people, I have to wake them up a little bit, but I appreciate you being here today, and it was my pleasure to talk about this subject. Thank you very much. Tamika.
Thank you, Carl.
Thanks, Carl.
Thank you all.
Thank you, Carl. Tamika is not in the program anymore. Maybe she had some technical difficulties. So you're gonna have to chat